Employing language constitutional scholars will analyze for generations, the Supreme Court, in a 5-4 judgment, hands gay Americans a supreme victory, making same-sex marriage the law of the land. The court's majority opinion was written by Justice Anthony Kennedy and reads, "It's demeaning to lock same-sex couples out of a central institution of the nation's society. The limitation of marriage to opposite-sex couples may long have seemed natural and just, but its inconsistency with the central meaning of the fundamental right to marry is now manifest." Justice Antonin Scalia was unimpressed by this kind of sweeping legal language, writing in a footnote in his contemptuous dissent, "The Supreme Court has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie." So, on what legal basis did the court find a constitutional right to gay marriage? What follows is a side-by-side look at how the key arguments of the majority opinion compare to the dissent of Chief Justice John Roberts. The first sentence of the majority's opinion makes it clear where they're coming from. Held, the 14th Amendment requires a state to license a marriage between two people of the same sex. The 14th Amendment, adopted after the Civil War, has since its enactment been used by the Supreme Court to block states from infringing on the rights of minorities. The gay marriage ruling says the court has long held the right to marry is protected by the Constitution. And then it cites the landmark civil rights decision Loving v. Virginia. That case invalidates laws prohibiting interracial marriage. Mr. Roberts rejects the majority's invocation of cases like Loving v. Virginia. He writes, "None of the laws at issue in those cases purported to change the core definition of marriage as the union of a man and a woman." The majority opinion reminds us, in Loving, the court invalidated a prohibition on interracial marriage under both the Equal Protection Clause and the Due Process Clause. The Due Process Clause is the provision of the 14th Amendment that states liberty may not be deprived without due process of law. The gay marriage ruling says the due process provision applies to certain personal choices central to individual dignity and autonomy, including intimate choices defining personal identity and beliefs. Therefore, the right to personal choice regarding marriage is inherent to liberty for gay Americans. Mr. Roberts says, with regard to due process, there is indeed a process due the people on issues of this sort, the democratic process. In other words, let the states decide. With regard to the Equal Protection Clause, the decision says the marriage laws at issue are, in essence, unequal. Same-sex couples are denied benefits afforded opposite-sex couples and are barred from exercising a fundamental right. Mr. Roberts responds, in his opinion, allowing unelected federal judges to select which unenumerated rights rank as fundamental and to strike down state laws on the basis of that determination raises obvious concerns about the judicial role. He also raises a point made by some conservative opponents of same-sex marriage. Why not legalize polygamy or other kinds of marriage? He says the majority offered no reason at all why the two-person element of the core definition of marriage may be preserved, while the man-woman elements may not. What are the implications of this monumental decision? There's the obvious. Gay people everywhere in America in short order will be able to get married. It's unclear, however, whether religious institutions can turn away gay couples or even gay individuals without risking their tax-exempt status. As a leader of the gay marriage movement told me, we'll discuss those issues later. That's the short answer.